So, good afternoon to all. I welcome you all to this webinar organized by ICSI IIP. My due regards to ICSI IIP for their invitation to me to speak in this webinar. I also thank all the participants for your attendance. So, friends, today our topic is transformative changes under IBC and related regulations. All of you are that recently, the Insolvency and Bankruptcy Code Amendment Act 2026 has been notified by the government in the official gazette on 6th April 2026. So we will discuss the changes affected or incorporated in the code through this amendment act. But before that, I want to tell you that in the recent past, Government of India has introduced several business-friendly laws or acts, and these leads to consolidate the position of our country to the ease of doing business index as published by World Bank. Now India has become the favored destination by the business communities and investors to put their money because of the introduction of these new laws or acts. To name a few, I can say GST. Now the booking of turnover is through a portal, online portal, and the transparency in these activities. This really reduces first of all, the risks of missing revenues or losing revenues by avoiding taxes. And also for the business entrepreneurs, there are now lesser amount of notices or litigations. Then I can tell you the various amendments in the Companies Act 2013. All of you are aware that a Companies Amendment Act bill is also under preparation. It will be placed before Parliament for the necessary approval very soon. And this bill will incorporate, starting from the incorporation of the entity in our country. So massive changes, the Government of India is bringing for only to provide comfort to the business entrepreneurs to do business in our country. Then I can say the amendment in Competition Act for combination of business through merger and amalgamations. Also the introduction of international arbitration procedure in our country through Arbitration and Reconciliation Act. Many criminal provisions which are there in these acts are also have become now decriminalized through the provisions of your penalties and fines. And these also leads to the increases the comfort level for the businessman. They can more freely now can discharge their activities. In fact, the recent introduction of BNSS, Bharatiya Nagorik Suraksha Sanhita, BNS, Bharatiya Nyaya Sanhita, and BSA, Bharatiya Sakha Adhiyam, in place of Criminal Code of Procedures, Indian Penal Code, and Evidence Act. If you see the main objective of the government to introduce a very friendly atmosphere, while the controlling provisions are kept inside in these laws, but at the same time, government provides a very friendly atmosphere in doing the business in our country. And friends, another very important law which government has introduced is Insolvency and Bankruptcy Code 2016. Government of India now in 2016 introduced a single law to address any sort of insolvency resolution process in our country. So you can understand that, I mean, you also know that prior to the introduction of IBC, there are several acts or laws in this country to address the insolvency resolution process. To name a few, Sikh Company Industrial Act, popularly known as SICA, then your Provincial Insolvency Act, Presidency Town Insolvency Act. In fact, our Companies Act 1956 also addressed to the insolvency resolution process to some extent. But the main problem with these laws or acts were these laws operated in the different plane. There is no cohesion between each other. And as a result of which they are not complementary to each other. So many times it happens when a litigant found that he may not get the favorable decision from the court, it is possible for him to lodge petition for the same matter under the provision of other act. And this happened. And as a result of which, what's happening, that litigation period increased like anything. The time period for getting the ultimate resolution is increased like anything. And you appreciate that since the time period increased, the associated cost, legal cost also increased to a great extent. As a result of which, this Government of India found that these individual laws are not very much effective within the country to have favored positions for the business. So they introduced this Insolvency and Bankruptcy Code with effect from 1st December 2016. And another very unique thing of this code is that it is a dynamic one. It is not a paper book type of act. And many provisions in this code had been incorporated out of the court decisions through various judicial interpretation, which later on incorporated in the act as the amendments. So dynamism of this code is also very, very unique, and this is very helpful because it also takes the market reality into consideration. And recently there is a massive amendments made by the Government of India in this code, which is our subject of discussion. So let me present my presentation, PPT. Just a minute. Is it visible? Can you see it?
Not visible, sir.
Is it visible now?
No.
No.
Yes, sir. Now it is visible.
Now it is visible. Oh, thank you. Just a minute. So it's visible now?
Yes, sir.
Okay, thank you. So before I start, there is a disclaimer from my side that the views expressed in this presentation are purely my personal views and interpretation also done by myself, and it can be viewed or interpreted differently by others. And in case of any legal requirement, I suggest all of you to consult your legal counsel rather than to depend upon this presentation. Okay. So friends, before I start discussion of the transformative changes, I personally feel that it is to understand properly the transformative changes is very, required to also understand the objective, the intention of the government of India to introduce this code in this country. I have already mentioned that first objective was to introduce a single law for addressing any sort of insolvency resolution process in the country. And instead of that fragmented various laws. So if you see the preamble of IBC, you will find it is mentioned an act to consolidate. So objective of the IBC is to consolidate and amend the laws relating to the reorganization and insolvency resolution of corporate persons, partnership firms, individuals, any sort of entity in a time-bound manner for a maximization of value of assets. So, this is the first time the act or code itself contains the time period by which this process is to be completed. And since it is a time-bound, it is done in a time-bound manner, it also maximizes the value of assets. So all of us know that it is, varies disproportionately. Time and value of assets are varies disproportional to each other. If the time goes up, the value of the assets comes down. To promote entrepreneurship, availability of credit, and balance the interest of all the stakeholders. Earlier, what's happened? The earlier acts only addresses the interest of a particular stakeholder who is the litigant. The litigant interests are only addressed by the earlier acts. But this act provides the balance, the interest of all the stakeholders, including priority and so. So this is, you have to keep in your mind this objective of IBC to understand properly the transformative changes done by the government of India. As I've already said that it is not a copybook type law or act, because many things of this act many provisions of this act are not amended, but are taken for the judicial hearing out of the court decisions, and which is based on the judicial interpretation. And the act is amended time to time to incorporate these judicial interpretations, which may be, sometimes it is conflicting maybe. So in that case, the interpretation done by the judiciary are statutorily addressed by the necessary amendments in the code. Okay. So if you see, there are altogether 7 amendments made in this code, including the current one. So first amendment made on 18th January 2018. This is called the Insolvency and Bankruptcy Amendment Act 2018. And the second amendment done on 17th August 2018. And the changes amended in the code are the homebuyers' recognition as financial creditors. Earlier when the code was introduced in 2016, I must say that the real estate projects are not considered by the legislation. So what will be the position of the home buyers in a real estate project? That was not visualized or not seen. So through these amendments, the status of the home buyers now incorporated in the code as the unsecured financial creditors. Okay. Then the reduction of COC voting threshold from 75% to 66% and the routine matter to 51% also affected through the amendment, first and second amendment. And this is with a view to expedite the resolution process. More percentage it is, and the possibility of getting quicker resolution is remote, so remote. Okay. So the third amendment was taken on 6th August 2019. It is called Insolvency and Bankruptcy Code Amendment Act 2019, and lots of change were made in the Amendment Act because of that judicial interpretation. Firstly, the mandating the application of uh, mandating the upper limit of 330 days is incorporated in the Act. You know, it is the objective of the code is a time-bound process. So through this amendment in the code, the Government of India incorporate the upper limit for completion of the process as 330 days. Then Section 12A, protection and minimum payout to the operational creditors. Section 13, Section 30 is amended. So by amending Section 30, the necessary protection was given to the operational creditors, stating that they will get through a resolution plan either the liquidation value as per the payable to them as per the waterfall mechanism, or the amount provided in the resolution plan, whichever is less. Then corporation restructuring, Section 5. Section 5 also amended in this amendment, and there it is said that the merger, demerger and amalgamations, are also considered for the resolution plan. Okay. Earlier, what's happened? You know, the objective of the IBC is to develop the entrepreneurship. So, first stage of the IBC is the revival. And revival means to carry on the business of the company as a going concern, on a going concern basis. But now, amending Section 5, it is said that, okay, if the resolution applicant say that I'll merge the business of this company with my existing business, it has become allowed. Okay. It is allowed by the government. Then representation through AR of the home buyers. As I said that the status of the home buyers were made as the unsecured financial creditors. So to represent to accommodate such huge number of home buyers in the COC meeting, the necessary amendment was introduced by incorporating Section 25A to appoint a authorized representative for them. Okay. Then binding nature of resolution plan, amended Section 31. The section resolution plans by amending Section 31 has become now binding to all stakeholders once it is approved by NCLT. They then amended Section 33, empowered COC to vote for liquidation of CD at any time. So, as per by amending Section 33, COC is now entitled to vote for the liquidation, to ask the RP to file the liquidation application of CD at any point of time. It is not necessary that the entire stage to be completed for the resolution, insolvency resolution process. So these are the amendment made through the Insolvency and Bankruptcy Code Amendment Act 2019. Very major amendments. Then we have the amendment in the year 2020. Two amendments are there. First is the Amendment Act 2020 and then the second Amendment Act 2020. The first one is for the minimum threshold for home buyers in order to prevent minor individual claims choking the system. You know what's happened since home buyers are also made the unsecured financial creditors. So they can also file individually they can file the application for the CIRP process, for initiating the CIRP process against the promoter or against the real estate company. Okay. So in order to, and that's why, I mean, and at that time that threshold limit also kept minimal, that 1 lakh rupees. So in order to circumvent this situation, it is amended, and by mentioning that home buyers can only file the applications jointly, either 100 home buyers jointly can file the applications or 10% of the home buyers of the entire project. So there is a stipulation incorporated in the code for the home buyer to file the CIRP for initiating CIRP application. Okay. Then insertion of Section 32A, providing immunity to new management of the CDs, manager to the CD, and by stating that CD's liability prior to the commencement of CIRP ceases entirely once the resolution plan is approved by NCLT. So by this insertion of Section 32A, necessary immunities are provided to the new entrepreneur to run the business. Then your protection of licenses and grants under Section 14. You know what's happened? Many companies who had gone to the CIRP process, they enjoyed the licenses or grants from the central government, state government, or local authorities. And what's happened, that government, once the company goes into CIRP, they withdraw this license or grants. As a result of which the new applicant, they didn't find it viable to apply for taking over the business of the company. So necessary amendment in Section 14, that is moratorium, made through this amendment. First amendment in the year 2020 to mention that such grant or licenses should not be withdrawn. It will be enjoyed by the company as a ongoing business, in its ongoing business also during the CIRP period. Then second amendment in 2020, that is a suspension of CIRP. Yeah, it is section incorporating the Section 10A. All of you are aware of that COVID-19 situation. So many companies came under insolvency resolution process because of the defaulting the amount, because there is a restriction in the business all over the world. So section 10A was inserted in this by this amendment act, and it is mentioned that from March 2020, for a period of 1 year, the default will not come under the provision of IBC. So it is not considered as a default. The provisions of IBC will not be applicable. Okay. Then 2021 IBC is mainly for the introduction of pre-packaged insolvency resolution process, PPIRP, and this is mainly for MSME companies, which significantly enhance the ease of doing business. So these are the earlier amendments made in the code, and now on 6th April 2026, the Government of India has introduced or notified, I'll say, some of the provisions are, come into effect, but some are not. The Insolvency and Bankruptcy Code Amendment Act 2026, which we will discuss. Okay. Friends, I have already told you that many provisions of the Act or code, IBC code, has been incorporated through the legal interpretation. And there are some conflicting decisions also made by the judiciary. So in order to address this conflicting interpretation by the judiciaries, necessary amendment has been made in the Code 2026, Amendment Code 2026. So mainly 5 landmark judgments are considered for these amendments. First one is the Vidarbha Industries Power Limited. Second one is Rainbow Paper. Third one is the Ghanshyam Mishra and Sons. Fourth one is the Amit Metallics, and fifth one is the Baiju. So if you see the judicial interpretations made by the Supreme Court in Vidarbha Industries Power, the court held that NCLT possesses residual discretion to decline admission of a financial creditor's application even where default is established, if the corporator can demonstrate mitigating circumstances, including its overall financial health or pendency of regulatory proceedings. So in this particular case, what's happened, the CD established that he has a huge amount to be collected from the government, and there is the certain, which is more than the claim which he has defaulted, and there is certainty to the collections, and as a result of which NCLT dismissed the application for initiation of CIRP. It gone to NCLAT, and NCLAT also uphold the order of NCLT. So Supreme Court says that Supreme Court also uphold these things and say that they possesses residual discretion to decline the admission if it can be shown by the corporate debtors that he has overall financial health. Supreme Court's decision in Vidarbha Industries and its subsequent clarification by later judgments. Key aspects of the decision and its interpretation include that the adjudicating authority has discretionary power under Section 575A of the IBC. It held that NCLT must apply its mind to relevant factors, including feasibility of initiating CIRP and the overall financial health and viability of the corporate debtor, rather than merely confirming the existence of debt and default. So Supreme Court is of the opinion that it is because if you see section 75, 75A, 7 subsection 5 subsection A, it is categorically mentioned that NCLT may approve the application. So Supreme Court also noticed these things and said that if NCLT finds that there is a feasibility and overall financial strength of the city is good, then just mere there is a date and there is a default on the basis of which NCLT may not approve the application of the financial creditor. However, this discretionary power cannot be exercised arbitrarily. There must be a good reasons not to admit a petition even if date and defaults are established. An example given is when an award or decree is in favor of the corporate debtor exceeds the financial creditor's claim and realizable. So what I already said, that they exhibit that they have that outstanding dues from government, it is receivable and recoverable, and it is more than the claim of the financial creditor. In practice, this become debtors too. As a result of this judicial interpretation made by the Supreme Court, debtors now, corporate debtors now started pleading before the adjudicating authority about their financial solvency. And this leads to the litigation. This also increases the time period for getting the insolvency resolution. The result was protracted pre-admission litigation, erosion of IBC's predictability as a creditor enforcement mechanism, and value destruction before moratorium protection even commenced. The Act, this Amendment Act, because so you can understand, no? Because this is a conflicting interpretation made by our Apex Code. Though Apex Code is, they have gone through the provisions of section 75A, but it is in conflict of the objective. So what's happened? This Amendment Act 2026 resolves this conflict, clarifies this conflict by substituting the word may, which was there in section 75A, with shall, across section 7, 9, and 10, with an explicit explanation that no grounds other than those specified. What are the grounds specified in the particular section? That establishment of default, completeness of application, and absence of disciplinary proceedings against the proposed resolution professional. Other than this, no grounds will be accepted by NCLT, and the adjudicating authority shall admit the application made by the financial creditor to initiate CIRP process. So this is the first, and this is the amendments made out of the judicial interpretation in our Vidarbha case. Then the second case is State Tax Officer versus Rainbow Papers Limited. All of you are aware of this case, that the Gujarat VAT Tax Authority, they claim they are also secured. Their status is also as secured creditors by the operation of law, because they say that when we give the registration to the assessee, so it is mentioned in the registration paper that if the assessee fails to make the tax payment, it will be recovered from its assets. So They claim they are also a secured creditor for the company, Rainbow Papers, and their security is through the operation of law. And Supreme Court decision in this state tax officer versus Rainbow Papers, the state government's claim for sales tax due secured by a statutory charge ranked as secured creditor under Section 53 of IBC. So, Supreme Court also gave recognition to this claim of the tax authority and said, yes, they are they are also a secured creditor. They will also be ranked as a secured creditors under Section 53 of IBC, and therefore had to be paid ahead of unsecured financial creditors. All of you know, not generally the government dues and state government. Also, it is as per the objective that the government dues will get lesser priority in the, in payment of dues to the creditors. But because of this Rainbow Papers judgment, they are now getting more priority even before the unsecured creditors. Okay. And so the banks and NBFC extending secured credit, this was alarming, and the government, because they have to now consider the whether this government authority, if they also be treated as the secured creditors, because generally the government dues are huge amount. So their recovery through this, or they are getting money through this process, will be very minimal. The Act corrects this directly. It inserts an expansion to the definition of securities interest in under Section 331. This Amendment Act 2026 addressed this issue by inserting a new section under section 331 as Section 331A. I think, yeah, it is 31A, clarifying that a security interest must arise from an agreement or arrangement between two or more parties and cannot be created solely by operation of law. So this Amendment Act 2026 say, look, the security interest is only created out of the operation of the process. If the charge is created in favor of a financial creditor, then only, or a creditor, you can say, then only that creditor will be considered as a secured creditors, not by the law process. Government dues secured by a statutory charge are excluded from the definition of secured creditors under Section 53. Rainbow Papers is therefore legislatively overruled. So since this is the Supreme Court order, it is now statutorily, addressed by the government through this Amendment Act. Government dues now rank at fourth priority in Section 53 order for limited to a 2 years look back period for the higher priority component, with remaining dues falling to the residual category. Now come the third landmark judgment, Ghanshyam Mishra and Sons versus Edelweiss ARC. Supreme Court's decision in Ghanshyam Mishra and Sons versus Edelweiss ARC introduced the clean set principle. Through the judicial pronouncement, Supreme Court said that after the resolution plan, after the approval of resolution plan, it extinguishes all pre-CIRP claims against the corporate debtor. And the principle is essential to the commercial logic of insolvency resolution. No rational, I already told you, that no rational acquirer will pay value for a business encumbered with an unknowable trail of historical claims. Maybe there is some claim which is not known at the time of submission of the plan. So I don't agree to, consider that liability, isn't it? Because it was not known to me when I filed the plan for the revival of the company. Yet until 2026 Act, means this Amendment Act, The principle rested entirely on judicial pronouncement in Ghanshyam Mishra and Sons case, rather than statutory text, leaving it vulnerable to challenge and inconsistent application. So, as you know that even though it is Supreme Court decision, but Supreme Court also said that all the order, all the judicial pronouncements are on a case-to-case basis. Unless, okay, definitely you can argue on the basis of this case, but there is no statutory validity of that particular thing. So till the Amendment Act came, it is only based on the Supreme Court direction in Ghanshyam Mishra case that once the resolution plan is approved, all the liabilities will go of the corporate debtors. The Act provides the statutory foundation that was missing. Claims not covered by an approved resolution plan now stand extinguished. The Act also introduces protection of grants, licenses, permits, and rights associated with the corporate debtor, ensuring these cannot be suspended, terminated, or withheld merely on account of past liabilities addressed in the resolution plan, provided continuing obligations are made. This is particularly significant for regulated business such as telecom, power, and aviation, where license continuity has been a persistent uncertainty for resolution applicants. So all this, I mean, what should I say, significant ease of doing business are provided through this amendment of 2026 Act. Okay. Next case is Amit Metallic Limited, India Resurgence ARC Private Limited versus Amit Metallic's case. And it is for the Supreme Court in this case considered a key issue regarding actual quantum of amount payable to a dissenting financial creditor. This is related to the payout to be made to the dissenting financial creditors. At the time of approval of resolution plan, you know that it requires 66% voting of the COC, share of the voting of the COC. Now the COC members who have dissented from approving the resolution plan, what will be their position? How much money they will get? Because they are not in favor of the resolution plan. So this question was raised in Amit Metallic's case, and Supreme Court considered this case and gave its verdict for this. The Supreme Court upheld the discretionary nature of the considerations provided in Section 34 of IBC and observed that so long as creditors of a particular class were being accorded a fair and equitable treatment under the resolution plan, the commercial wisdom of COC in approving or rejecting a resolution plan would reign supreme. So Supreme Court put emphasis on the commercial wisdom of COC. Accordingly, it will be fair and equitable if an approved resolution plan which provided for distribution among the secured creditors, including dissenting secured creditors, in proportion to their respective admitted claims, and the contention that a dissenting secured creditor should be paid a higher amount on the basis of the value of security and the contention that is dissenting secured creditors should be paid a higher amount on the basis of the value of security held by such creditor was dismissed. So in America, they said that the creditors who have descended from the approval, they have the higher security interest in the assets. The assets against which they have the security interest is much higher than the creditors who have approved the plan. So Supreme Court dismissed this idea that look, even then they have the uh, higher security interest, but the commercial wisdom of the COC is supreme. If this commercial COC approve the payment to the descendant's financial creditor as mentioned in the resolution plan, that will hold good. The Apex Code clarified that underlying objective of IBC is the corporate resolution and revival, not individual debt recovery. As observed that NCLT and NCLAT cannot interfere in a resolution plan just because a specific creditor is dissatisfied with his share. So also the decision of Supreme Court is in line with the objective, but the objective also said the balancing the interest of all the stakeholders. The ruling dictates that when a resolution plan is approved by a 66% majority, a dissenting secured financial creditor must accept the allocation assigned by the COC and it forfeit higher security claim. Now what's happened? The amended Act 2026 directly overrides and restricts the Supreme Court's ruling with a statutory floor by fundamentally altering how entitlements of dissenting financial creditors will be calculated under Section 32 of the Code. So, this amended Act 2026, through the necessary amendment in Section 32, prescribes how the claim of the dissenting creditors, though through by the commercial prudence COC with 66% approved the resolution plan, but how the payout to the dissenting creditors will be decided now. The amended Act introduced a strict legislative formula that dilutes COC's absolute discretion over DFC distribution, dissenting finance creditor distribution. The amendment codifies the lower of test. The COC cannot bypass this rule. Now, as per this amendment, they will get lower of the security value of the assets for which they have the security interest, or the amount whichever is mentioned in the resolution plan, whichever is less, or the amount which is mentioned in the resolution plan for the payment to the DFCs, whichever is less. So this is by amending this code, this lower of test is mentioned in the amended code. So now DFCs receive no less than their individual liquidation value or their waterfall entitlements under the resolution plan, whichever is lower. Earlier, dissenting was risky because COC could severely penalize the dissenter by limiting payments. The amendment partially corrects the anomaly of undercompensating exclusive security holders. However, it also prevents DFCs from extorting higher payout by firmly capping their maximum upside at the plan's liquidation waterfall equivalent. So it is partially, taken care of, but even then, something is mentioned. The interest of the descending financial creditors is protected in the code through this amendment in Section 32. I request all of you kindly make it an interactive session. So if you have any question, kindly ask me. Okay. So is it clear to all of you, I believe? The next landmark judgment which I want to discuss is the Glass Trust Company LLC versus Baiju Ravindran and others. In this case, the Supreme Court comprehensively analyzes how an application for CIRP may be withdrawn. So this particular case deals with the withdrawal of application 12A, section 12A, isn't it? It identifies it identifies four stages at which the withdrawal can be made, including, it means Supreme Court identifies four stages at which the withdrawal can be made, including entirely the stage where the application has been admitted by the NCLT, but the COC has not been constituted. At this stage, the application for withdrawal, so four stages, you also know that four stages are there by which the withdrawal application can be submitted. One of the stages is that the application is admitted, CIRP initiation application is admitted, but the COC is not yet been formed by IRP. And this is the case in case of Baiju. At this case, the application for withdrawal can be made by the IRP and the NCLT can allow a withdrawal only after hearing all stakeholders concerned, as the proceedings are now in REM. Otherwise, if it is one of the stages is that it can be withdrawn before the admission of the CIRP application, because that's no, that time it is in persona. But since it is in REM, so NCLT can accept the application, but only after hearing all the stakeholders' view concerned before withdrawing the application. It was observed by the Apex Court that in this case, it was imperative that the application for withdrawal be moved by the IRP before the NCLT, and NCLT hear all the stakeholders considered that and all the considered all the stakeholders concerned before allowing the withdrawal. However, this procedure was not followed. The hearing of all the concerned stakeholders procedure was not followed in this case, and nor the application was filed by the IRP. The withdrawal application was filed by Baiju's itself, one of the directors of Baiju's. The application for withdrawal was moved not by the IRP, but the former director of Baiju's, and it was moved before NCLAT instead of NCLT, and that to that application, the director moved before NCLAT, not even to the NCLT, before the NCLT. Furthermore, by invoking its inherent powers under Rule 11 of NCLAT rules, NCLAT allowed the withdrawal without hearing all the stakeholders concerned. But all of you know that Rule 11 has given the inherent power to the adjudicating and appellate authority. By exercising that power, NCLAT allowed the withdrawal. The withdrawal without hearing that in view of this irregularity, Supreme Court set aside the decision of the NCLAT. So, Supreme Court set aside. Now, what's this ruling in first he says on the legislative framework which prioritize balancing interest of all the stakeholders. It is also one of the objectives in IBC. Beyond that, the ruling has significant implications for insolvency law in India. The judgment discourages the use of inherent powers in a manner that might circumvent the legislative framework or act in a manner that defeats the right of the stakeholders who have a legitimate interest in the CIP process. It may be said that the decision strengthens the court's goal of achieving fair and balanced creditors' resolution and further defines the legal landscape for corporate insolvency in India. Now, so after this Baiju's case, it was felt that necessary amendment should be made for withdrawal of application. So this Amendment Act 2026 provides that withdrawal of insolvency processes will not be permitted, will only be permitted with 90% approval of Committee of Creditors. No such withdrawal shall be permitted before constitution of COC and after the first invitation of resolution plan for the corporate debtor, narrowing the window for withdrawal substantially. So, friends, that earlier 4 stages before the application is accepted or admitted, after the admission of the application, but before the formation of COC or before the EOI, publishing of EOI, 3rd stage. 4th stage is this one, that after the constitution of COC, 4th stage is before the submission of EOI. All these stages are now gone through this Amendment Act. And now the withdrawal application can only be filed and which should be approved by 90% voting share of COC after the constitution of COC by IRP or RP, whatever may be, but before the first invitation of the resolution plans. Only within this time period, the withdrawal application can be filed and can be considered by the adjudicating authority. So if it is through 90% approval, definitely you can understand that it is also agreed by the majority of the stakeholders. Are you putting any questions in the chat? So up to this, it is clear to all of you, I believe. Or if you have, I just pause for some time. If you have any question, you can ask me, please. Is it okay? The various amendments made in the Act, then these 5 landmark judgments which we have discussed now, the objective of IBC, any question, any point you have, because you know this subject is a very new one. So I expect that now we will share, we'll exchange our knowledge on this. Okay. Yes. So, friends, I will now discuss with you 2 very important committee report which form the basis for introduction of the Bankruptcy, Insolvency and Bankruptcy Code Amendment Bill 2025. And all of you know that this bill was presented before Parliament and on approval. Any question? Hello? Mr. Ravi, you have any question? And once and it is approved by the Parliament, and after getting the consent from the President of India, it is notified in the Gazette. So first report of the Select Committee on IBC Amendment Bill 2025. The Insolvency and Bankruptcy Code Amendment Bill was introduced in Lok Sabha. This bill was initially introduced on 12th August 2025. The motion for reference of the bill to a select committee of the House was moved in Lok Sabha on 28, 2025 by the Minister of Finance and Corporate Affairs, Srimati Nirmala Sitharaman. So what's happened when the Honorable Finance Minister put this bill before the Lok Sabha, she also passed a motion to refer this bill for the get consensus from the opposition party also. So she passed this motion to refer this bill to a select committee to what should I say, to suggest, to recommend the nitty-gritty of the amendments of the Insolvency and Bankruptcy Code. So the Select Committee on the Insolvency and Bankruptcy Code Amendment Bill 2025, chaired by Vaijant Panda, presented its comprehensive report to Lok Sabha on December 17, 2025. So Mr. Panda and his team, chairman of that select committee, and his team submit the comprehensive report to Lok Sabha on December 17, 2025 for the necessary approval of the House. Okay. Now, if you see the statement of objects and reasons which is mentioned in the report, we will find it clearly states that the necessity for improving the operation, the enhancing the effective implementation of Insolvency and Bankruptcy Code 2016. So it said the objectives of the committee to improve, find out the requirement to improve the operation, or to enhance the effectiveness of implementation. Because now many things, I told you that the India has now become a very preferred destination across the globe for doing business. So in order to have its effectiveness through these statutory provisions, it is the objectives of the Select Committee. The core objectives of these amendments are focused on achieving reduction of delays, the maximization of the value of all the stakeholders, and the improvement of governance standards across the process regulated under the code. So, though friends, all of you will appreciate that though the time limit is mentioned, all is okay, but reality, the time taken for insolvency resolution through this code has gone up manyfold. On a report published by IBBI, the average time frame for getting the resolution, CIRP resolution is, the average time is 780 days. This is average. So there are many cases where the time is more than that. So achieving the reduction in delays, and there are various reasons. I'm not going in detailed discussion on it. So there are various reasons for this delay, And because of the delay, the maximization value of all the stakeholders come down, because first of all, the cost increases, and also the associated asset, which will be through which the stakeholders can recover their claim, come down over a period of time. An improvement of the governance standard across all the processes regulated under the code. Consequently, the amendments seek both the refinement of existing statutory provisions under the code and the introduction of novel provisions that incorporate and adhere to global best practices for robust insolvency resolution frameworks. Keeping in view the importance of the bill and its wide-ranging implication, the committee decided to invite memoranda to obtain views, because the importance also understood by this committee, and that's why they invited all the experts, industry association, organizations, stakeholders, all sort of persons. They asked, they approached them to provide their opinion, their outlook, how to make the desired, how to meet the desired objective through this amendment bill. Okay. The bill intends to systematically overhaul the insolvency and bankruptcy conditions by mitigating procedural bottleneck, establishing alternate resolution pathways like creditor-initiated insolvency resolution process. You will see that a very, what should I say, very dynamic process, out of court process, which is called by CIRP, has been introduced in this Amendment Act by inserting certain sections. And also, what's happened, since the law plays in a global arena, and till now we don't have any proper registration for in our IBC code for group and cross-border insolvencies. So the committee also think to incorporate the provisions, proper provisions for group and cross-border insolvencies in the insolvency code. So the key observations and recommendations are separation of roles and appointment of liquidators, conflict of interest avoidance. The original code leaves liquidator appointments up to National Company Law Tribunal, while 2025 bill shifts this power to the Committee of Creditors. The Select Committee observed that a resolution professional might face a perverse incentive to steer a company towards liquidation rather than resolution of pocket extra fees. So what is the recommendation? The committee recommended that the existing RP must be statutorily ineligible to step in as liquidator. Instead, the liquidator should be appointed based on immediate recommendations provided by Insolvency and Bankruptcy Board of India to NCLT within 10 days of a liquidation order. So friends, all of you are aware, I believe, that earlier also what's happened, it was mentioned that generally the NCLT does not appoint the RP as the liquidator of the CD. And this was based on a internal memo circulated by IBBI to NCLT. Now the statutory provisions is Hello, Mr. Ravi, you have any question? Hello, Mr. Ravi, if you don't have it, please mute yourself, please. Mr. Ravi, please mute yourself. Otherwise, if you have any question, you please ask. So now the statutory provisions have been incorporated in this code, by which RP is debarred to become the ineligible, statutorily ineligible to become the liquidator of the corporators. And also another what's happened now, they are recommended. We'll see what is the actual effect of this recommendation. But they recommended these things, and they also suggested that the liquidator should be appointed by COC and not by NCLT also. NCLT will forward it to IBBI, whether any disciplinary complaint is against that person. If not, that person will be appointed as the liquidator of the company. Sorry. Then oversight the powers of COC during liquidation. Supervisory role. The bill formally replaces the stakeholder consultation committee with COC during liquidation, giving creditors active supervisory powers to leverage their commercial wisdom. The select committee also recommend or also observe that it is COC who will also supervise the liquidation process. All of you know that for liquidation, there is a stakeholder consultation committee, SCC, who monitor the process and who advise the liquidator accordingly. But this, as per the observations and recommendations of this select committee, they said, go away with this SCC concept. Let COC with its commercial wisdom supervise the liquidation process also. To prevent overlapping jurisdiction and continuous friction, the committee urged the IBBI to explicitly draft regulations defining the exact scope of COC's supervisory powers so they do not infringe upon the statutory duties of the liquidator. At the same time, they recommended that also that proper regulation should be there so that, I mean, there should be a conflict between the work of the liquidator and the supervisory role of COC. This is number 2. I have just noted down or you can say that I put the gist of these things. So if you are really interested, and I believe you should, it is available in IBBI website. You can go through the select committee report. 3, accelerated timeline for judicial appeals. The committee expressed grave concern over existing lack of prospective timeline for the disposal of appeals by NCLT, noting that legal logjams significantly erode asset value. So they also observed the time taken by the appellate authority to dispose of the appeal. And that's why they recommended that bill should include a mandatory deadline requiring NCLT to systematically dispose of an appeal within 3 months from the date of issue. So for the disposal of appeal, they recommended a timeline of 3 months. Then grounding cross-border insolvency frameworks. While the bill introduced an enabling provision allowing the central government to make rules regarding cross-border insolvency, the committee felt this left too much up to the subordinate legislation. The core tenets of the ancestral model law should be directly codified. So, you know, this cross-border insolvency is something which is to be considered or which is to be applicable across the globe. So, if there is any difference between the statutory provisions in India as compared to the other countries, the other country will not accept it, isn't it? And moreover, there is a model law framed by called as ancestral model law. And this model law is followed by most of the countries who have the provisions for cross-border insolvency. So the select committee also said that this should be considered directly codified in the code itself. But at the same time, they view that it can be given to the legislator, subordinate legislation, central government to make rules for cross-border insolvency. But my point is here, since it is generally what's happened, this IBC is the administrative ministry for IBC is Ministry of Corporate Affairs, MCA. But this cross-border insolvency involves many other ministerial departments, like your external affairs, definitely as external affairs ministry, your home ministry is also involved, your finance ministry is also involved. So all this ministry, how come a particular Ministry of Corporate Affairs can frame rules for for some activities which have the international effect? That is my point. So anyway, let's see what's happened. But this select committee said the ancestral model law can be codified directly. Must explicitly lay down the process for recognition of foreign proceedings, granting interim relief, cross-border judicial, because all these things are mentioned in that model law. Then fast-tracking resolution threshold. PPIRP, the bill initially mandated 60% voting threshold for unrelated financial creditors to greenlight a PPIRP. But then the recommendation, they said that it should be 51% in order to make PPIRP more effective. All of us know that it is the PPIRP, the intention for which the PPIRP was introduced, it is not met. So the select committee recommend that let 51% of the unrelated financial creditors approve this process, the initiation of this process. Decriminalization of technical lapses. Replacing criminal penalties, the committee strongly advocated for a pro-business environment by suggesting that technical or good faith error should not face criminal prosecution. Friends, I have also told you that in the many other laws, the criminal provision has been done away with the provisions of penalties and fines. So the select committee also recommends that this for the technical and good faith error, there should not be any criminal prosecution. Criminal penalties for contravention of a moratorium resolution plan and the non-disclosure of disputes by operational creditors should be decriminalized and substituted with civil penalties to decrease frivolous litigations. And since this is the criminal penalties or criminal provisions are there, you can understand that in order to save them same for the harsh measure to be taken, there are lots of litigations are there. Then mandating the clean set principle. Codifying the protections, the committee heavily endorsed the statutory reinforcement of the clean set principle, confirming that once a resolution plan is approved, past claims are definitely extinguished without absolving criminal liabilities of erstwhile fraudulent promoters. So these are the recommendations. These are the key observations and recommendations made by the select committee towards the IBC Amendment Bill 2025. So now we come to the Report of the Committee on Drafting of Regulations. You know that IBC is a procedural law. So, along with the provisions of the code, it is the regulations framed by the board, that is IBBI, also come into picture for the process of the insolvency resolutions or liquidation, any process under addressing the insolvency issues or matters in our country. So, after on the recommendation of this select committee, the committee IBBA also appointed a committee on drafting of regulations for the Insolvency and Bankruptcy Code Amendment Bill 2025 under the chairmanship of Sri Jayanti Prasad, full-time director of IBBA. And the mandate of the committee was to review the substantive and clarificatory changes introduced by IBC Amendment Bill 2025, evaluate recommendations from the Parliamentary Select Committee, and draft consequential modification to the existing IBBR regulations to ensure immediate seamless execution. So with this mandate, this Committee on Drafting Regulations for the IBC Amendment Bill 2025 was appointed or was constituted by IBBA. The committee's draft regulations act as the essential machinery needed to bring IBC Amendment Bill 2025 into active practice by formalizing COC governance in liquidation, tightening the timelines, and setting the ground rules for out-of-court restructurings, that is CIRP. The report seeks to transition India's insolvency framework away from chronic delay towards a modern value maximization ecosystem. Okay. An executive summary of the committee report outlining its core regulatory themes and proposed transformations is as below. First of all, it's the principles-based regulatory design. The committee adopted a strategic operational framework aimed at balancing the goals of the code with realistic market implementation. It prioritized. So, while preparing the regulations for the Amendment Bill 2025, this committee also considered the market reality. I said that IBC is not a copybook type of act. It always that the question of equity plays a very vital role. While you go for any litigation or any hearing before the adjudicating authority or appellate authority or Supreme Court. So the committee, this drafting committee also looks this practical market reality in designing their regulations. It prioritizes the fidelity to legislative intent, directly aligning regulatory and sub-clauses with the primary statutory revisions of the 2025 Amendment Bill, minimizing regulatory burden, preventing compliance duplication or administrative friction for stakeholders while retaining strong statutory oversight. So, what's happened? They said that they has, in fact, all of you know that the IBB has issued the discussion paper on the various regulations. And this committee, regulation of drafting committee, they also recommended that many things which are, what should I say, duplication of the things, they recommended that they should be taken out from the regulations. Fresh regulations for this amended bill. Process monetization, restructuring divergent regulation set, for example, CIRP regulation, fast track and prepack into a singular predictable operational standard. Key regulatory shift and operational changes. Empowerment of COC in liquidation. Since the select committee for IBC bill, they also recommended the COC to have the supervisory power for the liquidation process. This drafting committee also, they said that, and are arguably the most critical structural shift, the regulations phase out the advisory stakeholder consultation committee during liquidation. So they are also opinion to phase out this SCC. The committee of creditors transitions seamlessly from resolution phase to the supervisory governance body for the liquidation process. The liquidator's traditional quasi-judicially power to independently admit, reject, or value claims are curtailed. You know that liquidators enjoy some quasi-judicial power, but this drafting regulation committee on drafting of regulations, they are of the opinion to curtail the things, and instead major commercial decision during liquidation will require 66% voting threshold approval from the COC. They said, let that quasi-judicial power of liquidator, because also this leads to many litigations. Let this go, and the commercial decision during liquidation can be taken by COC with 66% voting share. Then they also recommended the resolution professional versus liquidator conflict of interest of the same thing. They said, let the RP should not be ineligible for direct appointment as liquidator. The regulatory flow establishes a system where IBBI recommends an independent liquidator directly to NCLT within 10 days of the liquidation order. C. Operationalizing the creditor's initiated insolvency process, CIRP. The bill introduces an out-of-court debtors in position mechanism for specified financial institutions. The committee drafted the operational regulations required to support this framework. Rules detailing the step-by-step notification of default and mandatory 30-day window for debtors to submit representations. Guidelines for RP to step in, collect claims, and build the information memorandum without halting day-to-day corporate management. Strict procedure bounds to ensure compliance with target 150-day completion timelines. So they recommended to have a regulation by which the CIRP to be completed within a period of 150 days. Tightening the timeline enforcement and multi-plan submissions. To curb massive value erosion caused by judicial backlogs and litigation delay, the committee integrated hard stop clock into corporate insolvency resolution process protocols by establishing stricter independent certification guidelines for IPs to check plan viability before putting it to a vote. So they recommended a stricter independent certification guideline for IP to check the plan before it places the plan to COC for voting. Multi-plan framework expanding the regulatory definition of a resolution plan to officially allow to curation and a submission of multiple or fractured resolution plans for a single corporate debtor to maximize assess of the value. Now you know what's happened. They recommend, and we'll see what the amended code will say. They say that the resolution plan, there can be multiple resolution plan for the different assets of the corporate debtor. Not necessarily the applicant, only one resolution applicant can file a single plan. There can be fractured resolution plans for a single resolution debtor, and they are of the opinion that this will maximize the asset value for the company. And instead, if I am to take the entire asset, so maybe I will not put many amount and much amount for that, for the entire thing. But if I am allowed to take a particular asset of my choice, definitely I will go for a higher value. So they said maximize the asset value recovery. They also recommended for multi-plan frameworks. Transitioning from criminal to civil penalties. They also recommended this thing that let the reflecting primary bill's policy shift towards discriminalizing technical and good faith lapses such as minor moratorium or resolution plan violation. The proposed regulations replace standard criminal referral processes with the structured civil penalties. This shift aims to reduce long-term litigation and clear backlogs before consent. Then they have recommended over the cross-border and group insolvency mechanism. The committee drafted the operational foundational rules enabling the central government to invoke the Center of Main Interest (COMI) doctrine and ancestral model law frameworks. So they said they will give the the foundational rules to the government to have the proper regulations for COMI, main business interest, center of main interest or business interest, and ancestral model law. The draft protocols clarifies procedural steps for mutual recognition of foreign insolvency proceedings, judicial cooperation and communication guidelines between domestic adjudicating authorities and foreign jurisdictions, and 3, expanding the definitions to formally cover corporate entities incorporated outside India with limited liabilities. So necessary regulations, they recommend that necessary regulations will be drafted to address these things: judicial cooperation, then your mutual recognition, etc., etc. And also they said that incorporation of ancestral model law framework also will be done through this regulation. Actually, these regulations are not yet come out. So unless and until these are published. It's very difficult to say what will be the actual structure of this group or cross-border insolvency resolutions. The Insolvency and Bankruptcy Code Amendment Act 2020. Acha. So this is the general recommendations or shift which is proposed by the drafting committee of IBBI for regulations, preparing regulations for IBC Amendment B. So any question if you have, I just pause for some time and then I'll shift to that. My next slides on IBC Amendment Act. Now we'll discuss the actual IBC Amendment Act, which is already notified by the government. Any question you have? Is it clear to all of you what I'm saying? Because, I mean, again, I'm telling you that this is a new subject, absolutely a new subject. And it's better if you can share our knowledge. Okay. So now we will discuss the IBC Amendment Insolvency and Bankruptcy Code Amendment Act 2026. I am sure all of you have gone through this by this time. So maybe at the cost of repetition, I say that the Insolvency and Bankruptcy Code Amendment Act 2026 received presidential assent on 6 April 2026. The legislation notified as Act number 6 of 2026 seeks to further amend Insolvency and Bankruptcy Code 2016. It is the 7th time in a span of less than 10 years, the Bankruptcy Code undergone 7th time amendment, and this time it is a huge one. The amendment was introduced through Bill number 107 of 2025 and was passed by both houses of parliament by Lok Sabha on 30th March 2026 and Rajya Sabha on 1st April 2026 through a voice vote before being sent to presidential approval. And this code received the presidential approval on 6th April, and on the same date it also notified in the official gazette. Published in the but effective, it was not effective at that time. The main aim of such amendments are to expedite the resolution process, providing legal clarity to counter conflicting judicial interpretations, recalibrate the balance between the secured and statutory creditors, and importantly, to incorporate new frameworks for group insolvency and cross-border insolvency. So with these all these aims, this Amendment Act 2026 has been introduced by government. The Honorable Finance Minister of Government of India, while presenting the amendment bill before Parliament, told the proposed changes into the code will lead to minimizing delays, maximizing the interest of all stakeholders, improving governance of all the insolvency processes through faster admission of insolvency cases by NCLT, out of court procedure to identify genuine business failures out of court mechanism, so that elements of informality can be introduced to avoid or to reduce procedural delay and induction of group and cross-border development. So these are the statements made by the Honorable Finance Minister, Government of India, and the, the act which is now published in the or notified in the official gazette also addressed to this requirement in the insolvency and bankruptcy code. Okay. Key highlights of IBC Amendment Act 2026. So what are the key highlights? Speedier admissions. The NCLT must admit or reject insolvency applications within a strict 14 days window. Friends, all of you know that when the IBC 2016 was first time introduced, the code says that the approval of the application or rejection, whatever may be the case, to be done within a period of 14 days by the adjudicating authority. And this process was followed for, I think, for many days. But gradually the delays are coming. I'm not going for the detailed discussion why the delays are. Maybe you can say that one of the reasons is the Indian judiciary, that question of equity, opportunity of to be heard. So whatever may be the reason, but there are delays in approving the plan. This amended act again reinforced that requirement and mentioned in the act itself now, through amendment, necessary amendment, that insolvency applications should be admit or reject within a 14 days window, 14 days time period on a strict basis. And liquidation timeline, liquidation processing must be completed within 180 days with a possible 90 days extension. So in both the cases, the shortest time has been mentioned, not recommended. It is already published, mentioned in the code, Amended Act 2026. Creditor control. The Committee of Creditors, COC, now holds more power, including supervising the liquidation process and appointing and reviewing the liquidators. So now the Committee of Creditors, they are holding much power for the entire insolvency resolution process for stage 1 revival, and now also for stage 2, that is liquidation. So they will now monitor the liquidation process, supervise and monitor, including appointing and removing. The court says if COC wants, it can remove the liquidator also. Group and cross-border insolvency, introduction of provisions for handling group company insolvency and cross-border cases. Earlier you have seen, I think it is section 234 and 235. Very scanty. For the, nothing was mentioned for group, but cross-border is very scanty. Now a detailed procedure, 240A for cross-border, I think 59A for group, has been inserted in the, we will discuss these things in more detail tomorrow, because you know this session is for 2 days, today and tomorrow. So all these things we will discuss more detail tomorrow. So induction of provisions for handling grouping company insolvencies and cross-border cases also incorporated in IBC Amendment Act 2026. Prepackaged insolvency extension of this is also another very bold step, I should say, taken by the government of India, which is now really a very much business friendly step. Extension of prepackaged resolution mechanism to all companies, not just MSME. Earlier, I think this is one of the reasons why PPIRP was not so favored, because it was only meant for MSME, and MSME, the MSME really constitute very small business group. So they are very reluctant to go for all these nitty-gritties of law. First of all, they are not aware of these things. It's such a small company. This now it is now available to all companies, but okay, we'll see the details. It is the unlisted public company, private company, all these things. Other things are we'll discuss in detail tomorrow. But the next thing is that it is now for all companies, not just for MSME. Penalties, increased penalties for frivolous filings up to 2 crores and penalties on insolvency profession. So this is also one of the incorporation made in this Amendment Act. These are all with the aim to lessen the burden on the adjudicating authority. So huge penalty of 2 crores for frivolous filing has been imposed. Electronic portal, statutory recognition for an electronic portal to improve transparency and efficiency in all procedures. So these are the key highlights of IBC Amendment Act 2026. Implementation status. While the Act has received President assent, as per Gazette notification, it shall come into force on such date as the central government may by notification in the official Gazette appoint. So it is only notified on 6th April, and it said that effectiveness will come through the subsequent notification in the official Gazette. We'll also discuss tomorrow. On 26th May, necessary notification has been made in the official Gazette by introducing some of the sections of this Act as effective, not the complete Act. We'll discuss tomorrow. Provided that different dates may be appointed for different provisions of this Act, and any reference to any such provisions or to the commencement of this Act shall be construed as a reference to the coming into force of that provision. All as it provides flexibility in implementation. Okay. So as and when it is notified that particular section, it will be it will come into effect. So I pause for some time. If you have any question, you can ask me. Any question on this IBC Amendment Act 2026? Any one of you wants to say something? Nothing. Okay. So before we go to the clause-wise summary of IBC Amendment Act 2016, can we have 15 minutes break? Anyone from the ICSI IIP? Anjali,
Okay,
are
sir.
you?
No issue, sir.
Sorry?
Okay, sir. It'd be good to have a break for 10-15 minutes.
15 minutes break, then we will again rejoin on. Now it is, what is the time?
20 minutes past 4.
It's 20 minutes. So, we'll again join on 4:35. Okay.
Okay, sir.
Okay. Thank you.
मेरे को देख के टेंशन आ रही है।
So can we start now? Hello? Can we start?
Yes, sir. Yes, sir.
Okay. So now we'll go for the clause summary of the IBC amendment.
Yes, sir, we can start, sir. Please start, sir. We are all here, sir.
Yeah, thank you. So as I already told you that Amendment Act mainly changes definition, admission and withdrawal timelines, committee of creditors functions, treatment of avoidance and fraudulent trading matters, liquidation supervision, security realization and distribution rules, new creditor initiated insolvency resolution process CIIRP, makes changes in voluntary liquidation, inserts provision on electronic procedures, group insolvency and cross-border insolvency. So for all these matters, necessary either amendments or insertions have been, or some omission also made in this Amendment Act 20. Sorry. Sorry. So clause 1 of the Amendment Act says that, gives the short title of the act. It says it will come into force, as I said, that as and when notified by the government, but it is published in the Gazette. But effectiveness will be notified subsequently by the government. And I told you that 26th May, some of the sections have already been effective. Now, clauses 2 and 3, generally it deals with section 3 and 5 definitions. So these clauses amended the definition section and they added registered valuer. It is mentioned that registered valuer is as defined in the Companies Act. So that the definition is added in the Act, IBC Act also now, the definition for registered valuer. Another very important thing is to clarify the security interest. It is mentioned by a explanation. It is mentioned by an explanation in the definition of security interest, and it mentioned by the explanation that exists only where it is created by agreement or arrangement between parties and not merely by operation of law. We have already discussed that Rainbow Papers Mill judgment, where Supreme Court order directed that, okay, the operation of law, if any security interest is created to the operation of law, the creditor will be considered as secured creditor, which is now statutorily, confronted by the legislature through this amendment, or you can say through the insertion of the explanation in section 3 of definition. Okay. Then also another definition has been incorporated, new definition as section 331A, subsection 31A, service provider. And this service provider definition includes IPA, IP. Hello, any question, Mr. Ravi, or otherwise please mute yourself. Service provider includes IPA, IPE, and also the insolvency profession. Also, the definitions for, this is done in section 5 now. The definition, added definition of avoidance transactions and fraudulent or wrongful trading, by mentioning that avoidance transactions are as defined in section 43, 45, 49, and 50. Will be considered as avoidant transactions, and fraudulent or wrongful trading will be as defined in under section 66 of the code will be considered as fraudulent or wrongful trading. These are all definition part we are now discussing. So clause 2 to 3 talks about the definition part, section 2 and section 5 of the code. Then another important thing through the amendment mentioned in this code, that is the initiation date. You know, the initiation date generally considered when the application is filed and it is not pending the approval of the application. When the application is filed, it is called initiation date. The date on which the application filed is called initiation date. But in case there are multiple applications filed before the adjudicating authority and none of them are, and all of them are pending, in this case, the initiation date will be considered the date of the first application, so filed with the adjudicating authority. So this definition is also mentioned in section 5, initiation date, with necessary amendment. Another definition for resolution plan explanation to include what I already told you, that sell assets to one or more plans. So resolution plan can have a multiple resolution plans for a particular city. For the various assets of the corporate debtor. Okay. Clause 4 to 10, these include section 7, and all these things we'll discuss more detail tomorrow. Okay. Clauses 4 to 10, these include section 7, section 9, section 10, section 12A, section 14, and section 16. Section 7, I already told you that the word may now has been taken out and it is now shall. So unless and until the four things, that default, then completion of the application, three things, sorry, and the resolution professional named in the application, there is no disciplinary action against him. If the things are hold good, then the adjudicating authority shall approve the CIRP application filed by a financial creditor under section 7. And section 9 also, it is the application filed by your operational creditors. It is mentioned, just a minute. Sorry?
तो अभी क्या बोला कि कमेटी रेकमेंड कर रहा है
Sorry, hello?
आ गया अमेंडमेंट
Any question? Mr. Robi, you have any question? Others, please mute yourself, Mr. Robi.
Sir, Prabhat here. Request to please cover this appointment for 7, 9, and 10, and then please differentiate from the previous law and the revised law. This is critical.
Yeah, I know that. I'm just giving you the gist now, and I'll discuss in detail tomorrow, okay? You can please note it down, Mr. Prabhat, your query. We'll discuss tomorrow in detail, because tomorrow we also have a session for 3 hours.
Okay.
Okay? Just. These clauses devise the process of admission of application under section 9. They require the admin authority to pass the orders with fixed period of records reason if delay. Clause 4 replaces section 7.5, what I have already told you, including no further ground is to be considered to ascertain default. Clause 8 replaces section 12A, regulates the withdrawal application. This also I have told you that 12A to a withdrawal can only be done after the constitution of COC and with 90% approval. And before the first resolution application for first asking for the resolution plan within that period. Line clarifies the moratorium also applies where the okay. And you know what's happening, that now section 14, which is moratorium, as per the amended act, this moratorium will also applicable for the surety. This was not there earlier, but this amendment act involved that, because you know, as per the contract act, the surety can ask the corporate debtor to make good of his losses, because contract act says so. So now the amended act says that the moratorium period is also applicable for the surety. And another thing is that section 16, that appointment of interim resolution professional, is that it will be automatic. Interim resolution professional, if it's named by the COC or the applicant, he will be appointed as the interim resolution IRP, provided there is no disciplinary action against him, and no separate order is required from the adjudicating judge. Clauses 11 to 17, it covers section 18, 19, 21, 22, 25, 26, 28A. 28A is a new insertion, I'll tell you. These clauses deal with claims, cooperation, committee of creditors, avoidance actions, and transfer of guarantor assets. Clause 11 clarifies the interim resolution professional must verify claims and, if required, determine their value. So you know that section 18 also talks about the duties of IRP for verification of claim. So this is also amended through clause 11 of the amended act. Then clause 12 bordens the obligation of assistance from personnel. This is section 19. So now what's happened? The amended act said that the promoters of the CD and also the persons who are engaged with the management of the CD are supposed to provide cooperation to the IRP or RP. And this includes RP also. You know that liquidator can also file section 19 application. So there, I mean, the necessary cooperation should be given by RP to the liquidator. Then this is section section. Clause 17 provides that in liquidation, the committee of creditors will also supervise the liquidator and continue in certain ongoing liquidation cases. So this is your section 26. Section 26 is your, no, sorry. This is section 21, I'm sorry. So COC will continue to supervise the liquidation process. This is through an amendment under section 21 of the code. Then is this clause 15 states the resolution professional must file application regarding avoidance transactions. Clause 15 is your section 25. Clause 15 is section 25, which empowered the resolution professional to file the application regarding avoidance transactions or fraudulent or wrongful trading. Clause 16 says that such applications do not affect the CIRP or liquidation process, and that completion of those process does not stop continuation of the proceedings. Clause 17 inserts a new section 28A. You know what's happened now? A new section has been incorporated in the Amendment Act, section 28, which says if a person holds security interest in the assets of the personal guarantor, that person can sell that particular asset as the CIRP process of the corporate debtors with the approval of COC. Get my point? Generally, the relinquishment of interest is at the time of liquidation, but this new section 28A says that if a creditor holds the security interest of an asset of the personal guarantor or corporate guarantor, he can sell this asset as CIRP process with the approval of COC. And if the corporate guarantor or the personal guarantor is under CIRP, then with the approval of the COC of that personal guarantor or the corporate guarantor. Clear? Similarly, in case of bankrupt, and it will be, and that sale process will be given to that personal guarantee insolvency process. It will not be considered for the CIRP process. If that personal guarantor or corporate guarantor also involved in CIRP process, and in case of bankruptcy, it will be sold with the approval of bankruptcy trustee, and the sale process will be constituted as the bankruptcy estate. If it is not clear, then please ask me. Then clauses 18 to 20. Clauses 18 to 20 consider section 30, 31, 33. Section 30 is the resolution plan. Separate treatment for dissenting FC, clarify from the equitable treatment. Clarify fair and equitable treatment. So we have already discussed that how the money to be provided, that the lower of the liquidation value of the secured asset, but of the asset, liquidation value of the asset for which the security is created, or the amount which is provided in the secure resolution plan for the dissenting financial creditor, whichever is less. So this section 30 is for that. It is amended accordingly. Section 31 is the approval of resolution plan. Allow the phase approval of resolution plan and distribution of money, and also allow rectification to the COC of the resolution plan before rejection. So you know what's happening. When a resolution plan is approved by COC, or not approved, when a resolution plan is in discussion with COC, it is seen that lots of time is passed also to decide upon the distribution of resolution money which is received through the resolution plan. How it will be distributed to the secured creditors, unsecured creditors, etc., etc. Okay. So operational creditors. So now this section, amendment in section 30 made so that the approval of resolution plan by the adjudicating authority can be done on a phase manner, phase manner. Phase wise, matlab, first the adjudicating authority can approve the resolution plan itself, then within 30 days, the adjudicating authority also approve the distribution of money. So the entire process can be done very fast. Expeditiously. Okay. So this is the amendment made in this thing, in this section 31. And another thing, it is mentioned in section that the adjudicating authority will notify COC if some defect is there noticed by the adjudicating authority in approving the resolution plan, which is already approved by COC. Before rejection of the plan, necessary scope should be given, necessary time should be allowed for rectification of that defect, curing that defect. And section 33 is the liquidator possibility of restoring CIRP before. Okay. So section 33 is all this 18 to 20 cross section 33 is that, first of all, is that liquidation order is mentioned by amending section 33 that the liquidation order has to be passed within 30 days from filing the application for liquidation. Another thing, it is mentioned that if COC so applied, the restoring of CIRP process can be ordered by adjudicating authority before ordering the liquidation. But entire thing is to be done within a time period of 30 days. Am I clear? If COC so, opted, adjudicating authority may pass the order for restoring the CIRP once again before passing the liquidation order for the, because if there is no resolution plan, it is mentioned that 33 said that the NCLT will pass the liquidation order. So as per the amendment, NCLT may order for restoring the CIRP once again if it is so desired by COC, but the liquidation order is to be passed within a period of 30 days. I think I am clear. The clauses changes rules on resolution plans and liquidation. Clause 18 inserts a new requirement for payment to financial creditors who do not vote in favor of resolution plan. Sets a minimum standard for such payment. We have already discussed section 31 and 30. Clarifies that such distribution is fair and equitable to those creditors and provides a non-applicability rule for certain already advanced cases. It also requires the committee of creditors to record reasons for approval. Clause 19 amends section 31 to allow staged approval of implementation of first and distribution letter in some cases, allows notice to rectify defects before rejection, imposes a 30-day timeline for orders, protects license, permits, and similar grants from suspension or termination during the remaining period if obligations are made, and provides for extinguishment of prior claims against corporate debtor and its assets on approval of the plan, subject to the explanations included here. Section 20, clause 20 changes section 33 to expand the liquidation order framework. allow restoration of CIRP in certain circumstances before liquidation is ordered, provide the restoration can happen only once, and insert timelines for passing the liquidation orders. Okay. So clauses 21 to 33. It covers section 34, a new section 34A, 35, and this 38 to 42. All these sections are now omitted. These are generally claim verification by liquidator. 43, 46, 49, 50, 52, 53, and 54. So section 34 is the appointment of liquidator. And we have already seen that it is mentioned that no RP will not be appointed as liquidator. 34 is the replacement of liquidator by COC with 66% vote. This 32, 35 is the claim liquidator to maintain in updated list of claims and COC to supervise. And now what's happened, it is mentioned that liquidator will not invite for fresh claim during liquidation process and will not verify any claim. It will only maintain the updated list and a COC to supervise the list. And so this 32 to 38 to 42. All these sections are now omitted, which are related to the claim verification by liquidator. Section 43 is look back period. Look back period for now will be from insolvency commencement date for preferential transactions, and same for the 46. Section 46 is for the undervalued transactions. It will look back period will start from the insolvency commencement date. Section 49 says transactions deferring creditors extend period is Section 49 is the transaction deferring the creditors, and these provisions is now extended to the related party of the corporate debtors. This is made through amendment. Section 50 is the extortionate revises extortion transactions revises the relevant period to 2 years preceding the initiation date and ending on ICD. So extortionate transactions period, that it is revised and it is said that section 50, it is made necessary amendment, say that extortionate transactions period will be relevant will be to 2 years preceding the initiation date and ending with ICD. So within this period, the RP or the liquidator will see whether there is any extortionate transaction. Section 42 is the secured creditor must inform liquidator. Okay. Section 50, you know that Section 52 talks about the realization of security interest. And you know earlier what's happened, that at the time of filing the claim form, the financial creditors or the secured creditor says that whether he will relinquish his security interest or not. If he doesn't relinquish his security, then it will not form a part of the liquidation estate. Now, through this amendment to section 52, it says that the secured creditors has to inform liquidator about his decision whether to retain the security interest within a period of 14 days. Okay. And if it is not done within a period of 14 days, it will be deemed as relinquishment. Because now the liquidator will not invite for any claim or not verify any claim. only the liquidator will maintain the updated list of claims. So section 52 says that the secured creditors have to inform the liquidator whether he will relinquish or not his interest. Section 53 waterfall mechanism, we have already discussed these things in our rainbow paper mill cases, that necessary amendment has been made and by which the government tax authorities, maybe they have the security interest through the operation of law, but they will be come on the fourth stage of the pyramid. Okay. Then section 54 is the dissolution. Dissolution can be made, I mean the completion of liquidation dissolution application has to be made within a period of 180 days, which can be extended for 90 days. So if you see the notification, it is mentioned that these clauses substantially revise the liquidation framework. Clause 21 changes section 34 so that when liquidation is ordered, the adjudicating authority refers the matter to the board for recommendation of an insolvency professional to be appointed as liquidator, yes, and also state that the resolution professional in CIRP shall not be appointed as replaced as the liquidator for that corporate debtors. Clause 22 inserts new section 34A, we have already discussed, that can be replaced with 66% vote. Section clause 23 amends section 35. Liquidator must maintain the updated list of claims and no need to invite for claim or verification of claim. Clause 24 widens the section 36(3)(f) to refer the proceedings relating to the avoidance transaction, fraudulent wrongful trading, or section 47. Clause 25 omits section 30 to 48, we have already discussed. Clauses 26 to 30 adjust look back wording and related provisions in section 43, 46, 47, 49, and 50. Clause 20 replaces section 47 so that creditors, members, and partners may apply where certain transactions or trading have occurred but were not reported by the liquidator or resolution professional. It also allows the disciplinary action even where the non-reporting is found. Clauses 31 and 32 amend section 52 and 53 regarding the relation of security interest, deemed relinquishment if not informed within the 14 days, agreement among the secured creditors, in some cases deduction and transfer of certain costs and dues, treatment of part secured debts, distribution of government debts. Yeah. Clause 33 amends section 54 where liquidation and dissolution apply within 1 to 2 days. Yes, we have done. So clauses and the clauses 34 and to 40, these clauses deals with the pre-packaged insolvency resolution process. Insert a new chapter 4A on creditor initiated insolvency resolution process. Four A is for that CIRP. And clauses 34 to 38 amend section 54A, 54C, 54F, 54L, 54N, including lowering certain approval threshold from 56 to 51% and marking related procedural changes. Clause 39 omits chapter 4 of part 2. Clause 40 inserts section 58 to 58K. These new provisions state which corporate debtors are eligible for creditors initiated process. We will discuss these things in details tomorrow. After section clause 472 after section 240A, new section 240B and 240C are inserted. Section 240B allow central government to provide electronic portal for insolvency and bankruptcy procedures under the code. Section 240C allows the central government to prescribe manner and condition for cross-border, I have already told you. Cross-border insolvency proceedings, including recognition, relief, judicial cooperation, assistance and coordination with power to adopt provisions of the code or the Companies Act 2013 as required. Clause 72 amend section 242 to insert subsection 1A, giving the central government power to remove difficulties for up to 5 years from the commencement of the Amendment Act. So these are the clause-wise summary of IBC Amendment Act 2016. Sorry, this is all. I am sorry. These are all 26. So, friends, I have summarized because we will discuss it tomorrow, but now I have summarized the sections which are amended by this Amendment Act. Yeah, sections of IBC, here 2016 is right. The sections of IBC 2016 is amended through this Amendment Act 2026. So these are the sections. Section 7, initiation of CIRP by financial creditors. We have already seen that may is replaced by shall. Section 9, application for initiation of CIRP by operational creditors. There are certain documents required which are for which the section 9 is amended. Similarly, for section 10 also, some amendment for requirement of documents is made. Details will be discussed tomorrow. 12A is withdrawal or application admitted under section 7, 9, 10. We have already discussed. Moratorium, prohibition of activities. Surety will fall under the provision of moratorium. 96, interim moratorium for applications 94 and 95. And this interim moratorium as per the amendment is not automatic. Earlier what's happened, when the application is filed, interim moratorium will start. Application under section 94 or 95 filed, then the interim moratorium start. But now as per the Amendment Act, it is not automatic. The necessary application can be filed by RP and it is the discretionary power of the adjudicating authority. Section 3 explanations has been inserted, clarifying no security interest exists through operation of law. We have already discussed these things. So I just I list out the amendments and which are the new insertions and which are omitted altogether. Explanation to clause 31, service provider, new 31A, registered value as per section. Section 5, multiple resolution plans, that also we have discussed. Now it is possible, including sale of assets. Section 30, minimum payout to the dissenting financial creditors. Section 30 amended for this purpose. Section 31, the A would pass phased approval. We have also discussed this thing. Implementation and distribution enables rectification opportunity to COC before rejection, extinguishes undecided claims against CD after approval. Significant codification of clean set principle, however, proceedings against the erstwhile promoters can continue. The AA will be required to pass an order approval of resolution plan within 30 days, failing which it will be required to record the reason. Now the Act categorically said, if the adjudicating authority does not pass the order, approval of resolution plan order within 30 days, then it has to record the reason in the order. Section 34 also amended, resolution provision would not be eligible to become a liquidator, yes. Section 21, the COC will now supervise the liquidation process. Other creditors may participate in the process as non-voting members. The liquidator will not invite or verify claim. Section 32 to 42, 38 to 42 have been deleted. We have just seen. Central and state government dues will not entitle to priority of secured creditors. Yes. Section 52, secured creditors must identify security interest within 40 days, else deemed relinquishment. Any asset which has been charged to move more than one lender can only be kept out of the liquidation estate on approval of 66% of value of the creditors having charge on the said asset. Any creditors, okay, I told you that if a secured creditor doesn't want to relinquish its security interest, it has to intimate the liquidator within 14 days from the liquidation commencement date. Okay. Now there is another scenario. It is also mentioned in the amended act, section 52. Suppose there is a asset for which the charge is created for more than one lender. For more than one creditor, the charge against a particular asset is created. In that case, that particular asset can be taken out from the liquidation estate on approval of 66% of value of creditors having charge on the said asset. So, if the 66% of the creditors for which the charge is created for the same asset agrees, then only the asset will be taken out from the liquidation estate, otherwise not. Clear? Any creditor intended to realize security interest outside limit will have to deposit its pro rata share of CIRP cost, liquidation cost, and workers' dues with the liquidator from the proceeds of the sale. Again, an amendment made in the Act itself. Otherwise, it was earlier it was mentioned in the section Regulation 21A. Now it is amended in the Act. Section 53, explanation incorporated for the treatment of government dues, preserving inter-creditor contractual priorities among secured creditors. And this 53, we have to read with section 3, where security interest not through operational law. And section 53, there is an explanation incorporated for this. Section 19%, extended cooperation to IRP promoters, persons associated with management, including RP. I have already told you. Section 26, application in respect of certain transactions or trading not to affect process, necessary clarification. Section 54A, prepackaged insolvency resolution process. Now it is applicable for all companies. Okay, some restrictions is there, but not only reserved for MSME. Section 66, fraudulent or wrongful trading, liquidator action can be considered. Section 164A, undervalue transactions in bankruptcy process. Section 215, procedure for submission of financial information. And this section 64A, 183A, 65, 67A, 67B, 67C, 235A, all related to imposition of penalties. So these are the steps towards the decriminalization of the provision. These new sections are incorporated through Amendment Act 2026. This will be here. It will be 2026. Section 2028A, new provision permitting transfer of assets, personal, corporate guarantors during insolvency subject to COC withdrawal. That also we have discussed. 58A, B, C, D, E, F, G, H. all are related to CIIRP, Corporate Initiated Insolvency Resolution Process. And these are all the new incorporation in the code. Similarly, this is also related to CIIRP. Withdrawal of public announcement, application approval, case application. 59A is the power to make rules and initiating proceedings for coordinate cooperation of corporate debtors of group insolvency. 40B, Central Statutory Authority to mandate and operate the electronic portal for all insolvency and bankruptcy processes. So this section is also newly incorporated in the code. 40C to 40C, power to make rules for cross-border insolvency. And these sections, all these sections are omitted from the code. Section 38, consideration of claims. Section 39, verification of claims by liquidator, consideration of claim by liquidator. Everything related to the claims verified acceptance by the liquidator. 40, admission claim by liquidator. 41, determination valuation of claims by liquidator. Appeal against decision of the liquidator related to the claim. 47, application of creditors in cases of undervalued transactions. 74, punishment for contravention of moratorium or resolution plan. 76, punishment for non-disclosure of dispute or payment of debt by the operational creditors. Show cause notice to IPA or its members or IU. Section 219. All these sections are omitted now. 235A, punishment where no specific penalty or punishment is provided. This section is also now omitted. Okay. Section 55, fast track corporation insolvency resolution plan is now omitted. Section 56, time period for completion of fast track CIRP omitted. 57, manner of initiating fast track CIRP omitted. 58, applicability of chapter 2 to this chapter, means fast track corporation insolvency process is omitted. And through these sections, the timeline prescribed for NCLT and NCLT. 12A3, withdrawal of CIRP. This application has to be approved or rejected, whatever may be, within 30 days of application. Section 33, 2A, liquidation order within 30 days of application. Section 54(4), dissolution order within 30 days of application. Section 61(6), disposal of appeal within 3 months. Disposal of appeal by NCLAT within 3 months. So these things, this time period is mentioned in the amended act itself, and definitely it will be now incorporated in the code, body of the code. So let's hopeful that it should be followed properly and we will have the faster resolution for the insolvency resolution process. So these are all from my side. I'll discuss with you in detail the provision tomorrow. I'll also let you know. Just a minute. Take me. I think I can stop.
Okay, sir.
Just a minute. So as I told you that, is it visible? Can you see this?
Yes, sir.
Is it visible?
Yes, sir.
So there are, you know that necessary gadget information has been published on 22nd May 2026 by mentioning that these are the sections are now effective. Okay. And there are certain sections, okay, I don't have that list here now. We'll discuss tomorrow. Are still that no notification passed, so that means those are not made effective. For example, CIIRP, group insolvency, your that electronic portal, and I think that cross-border also. Yeah, cross-border also, this notification has not been made for the effectiveness of these sections. So, okay, we'll discuss these things tomorrow. So, any question you have? I am happy to answer this. Anything you want to know? Is it clear what I am telling you? No, no, no. Okay. So, okay, Anjali, you are there.
Yes,
Okay, sir.
yes, sir. Yes,
So,
sir. I'm here.
Thank you, sir.
yeah, can you conclude the session today?
Yes, yes, sir. Yes, sir.
30%?
Thank you very much, sir, for such a nice session.
Thank you so much.
Okay, okay.
So we are meeting tomorrow at same time for second session.
Anjali, please tell me what you're saying. Anjali, what you are saying?
Sir, thank you very much for such a nice session. And we will meet tomorrow at same time.
Same time and same link, I believe, isn't it?
Yes, yes, sir.
Okay, so
Topic is also the same.
okay, so tomorrow we'll meet again on 2:30. Okay,
Thank you. Thank you.
thank you.
Thank you to all. Bye.
Okay, thank you everyone. अब कहाँ से लीव होगा, कटेगा।